Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Risa Iris Awonia, and today I'm going to take you through the management of family property. So what is family? Usually when we mention family, people tend to think of the nuclear family, which is the husband, wife, and children. But in the Ghanaian context, when we talk of family, it goes beyond that. We do not mean the husband, wife, and children, but we lean towards people who have lines or connections with their kinship. So in Ghana, in the context of customary land law, a family generally refers to a group of persons or individuals whose precise kinship relationship to each other are known, and that these people identify themselves from one common ancestor. So in Ghana, we have two types of families, which are either matrilineal or patrilineal. And matrilineal families are usually within the Akan communities, and patrilineal families are in the Ewe and the Ga communities. So these people trace their family line to one ancestor. The family in a matrilineal society usually lean towards the mother's side or the side from the woman, and the patrilineal lean towards the father's side. So that is what makes a person a member of a family. The mere fact that you have been born by, say, an Ewe man, you are a daughter to an Ewe man, does not necessarily mean that you are a member of the family of that man. It is the nature of the family that will determine how your family property is managed. Under Section 2 of the Land Act, I stated earlier that the allodial title interest is either held by the stool, the state, the skin, clan, or family. So a family can own the allodial title ownership. A family can own it. And it can be acquired either by conquest or pioneer discovery and settlement, gift, purchase, or agreement. However, family property is very unique. It changes, and it can also be acquired through various means. In the case of Chechewa and Akwa, the court stated that for the acquisition of family property, the general rule is that the property acquired with family resources becomes family property. So let's say you and your aunts in a matrilineal society, you all bring money together to acquire land elsewhere. That land generally will be a family property. However, because it's a general rule, you should know by now that there will be exceptions to it. In the case of Kujo and Kwachi, the court stated that where a member acquires property with a small contribution from the family, the property does not assume the character of family property. So let's say you wanted to buy land for 100,000 cedis at maybe Adenta, somewhere in Adenta. And you were able to gather up 70,000, but you needed 30,000 to help you acquire the land. And you asked your cousins or your uncles and your aunties for support, and they were able to gather up the remaining 30,000 to help you acquire the land. In this case, you'd realize that the contribution they made was small. So as per the decision in Kujo and Kwashi, that property you'll be able to acquire does not assume the nature of family property. It will be your own property. However, another exception to this rule, which was stated in the case of Labi and Kato, is that the fact that a family member benefited from financial support from the family towards their education does not make the property that family member acquired subsequently form the nature of a family property. So in that case, the deceased built his house on a self-acquired land, and after his death, the brother of the deceased claimed that the property was family property because, in his opinion, the family saved money and they put Labi through school and education and all of that. And it was as a result of it that he turned out to be the man he was. And he was able to buy land and build on it. So in his opinion, the land, including the building attached to the land, formed a family property. But the court reasoned that no. The mere fact that you supported your family member to go through education with financial support does not mean that any property he acquires assumes the nature of a family property. Also, where a member of a family acquires land with his own resources and other members provide the funds to build on the land, it becomes a family property. This is an addition to the general rule. The general rule was that when the members of the family contribute to buy land, the land is family property. But in this case, it's stating that if a member, you were able to buy your own land, but in building on the land, you sought for support from your family members, and may say you built a house on it. That house, including the surface soil which forms the land, assumes the nature of a family property. The case of Boafo and Stewart supports this principle. However, where a member makes an extension to an already existing family farm or its improved same, it still remains a family property. So let's say your family had built a 2-story building on their land, somewhere in maybe Ningo Pampram, and you got money and you decided that, you know what, let me extend the house. Let me extend it to a 5-story building. The mere fact that you have extended it or you added something to it does not mean that it is your individual property. It is still going to be the family property. And the case of Nkunya and Anefi explains this perfectly. The case of Emisa Badu and Abadu stated that where a member builds a house on family land, the land remains family property and the house becomes a part of the family property, with the member only retaining a life interest in the land. So let's say your family has a land and you decide to build your house on it. The mere fact that you built your house on it does not mean that the house and the surface, which is the land, is now yours, your individual property, which you can use in the way you want. No, in the Emisabadu case, the court stated that when you do that, when you build your own house on family land, the house which you built forms part of your family property and you only have a life interest in the house you built. So upon your death, your widows and children will have the right occupying a part of the house. So it cannot be a subject of your personal property because the house you built on the family land maintains or forms part of the family property. These are the various ways in which you can acquire family property in addition to the provisions made under Section 2 of the Land Act 2020 Act 1036. As a member of a family, you have several rights in which you enjoy. And of course, with rights come responsibilities, or in this case, obligations which you must fulfill. A member of a family has the right to reside in family house, but without power to determine which room you would occupy. So if you want to stay in your family house, you do not go there telling the people that I want the master bedroom or I want this particular room. The room they give you is the one that you have to reside in. You also have the right to be supported in your education or to start a business or a trade. As a member of a family, you have the right to be supported whenever you want to pursue education or you want to start a business or a trade. When you die, your family must also contribute to your funeral and other expenses which should be payable. So in the event of your death, so when you die, your family must help bury you because as a member of a family, it is the rights with which you're entitled to. However, there are obligations which a member of a family must ensure to fulfill. The member of a family must contribute towards the payment of family debts. Member of a family must also contribute towards the payment of debt of individual members. As a member of a family, you have a serious obligation to this. You must also assist your needy members and you must pay funeral and burial expenses of deceased members of your family. These are the various obligations which over time you have come to identify with members of the family. As a general rule in law, family property can only be alienated by the head of the family and the principal members of the family. The case of Alote and Abrahams defines clearly that it is the head of the family and principal members of the family who alienate family property. However, where the principal members of the family act on their own to alienate family property without the consent and concurrence of the head of the family, that grant will be void in law. It is not recognized because the head of the family must be present in all of these transactions. It is a necessary factor when it comes to the alienation of family property, which everybody must keep in mind. The head of the family is very important in the granting of any interest or alienating of family interest in the family properties. However, when a family member or the members of the family feel that any alienation in respect of the family property has been made with which they are not comfortable with, the courts have given instances where they can apply for such a transaction to be set aside. In the case of Eje and Apieje, the Court of Appeal outlined the conditions to be satisfied when the family is seeking to avoid a transaction with which the head of the family and principal members of the family made in relation to family land. The court gave the conditions that the person seeking to set aside a transaction was the proper person to represent the family in a suit relating to the family land. Also, that the members of the family were wholly ignorant of the transaction, which means that they were not even aware that that transaction had been made. That the family had not by any conduct subsequent to the date mentioned acquiesced in the transaction, which is this particular point means that the members of the family had not by their actions or inactions allowed the transaction to go on. They must have not even been aware of it, or that immediately they found out, they decided to take steps to prevent it from happening. The family must have also acted timeously and exercised due diligence to avoid the transaction to be made. So these are the conditions that must be met if a family makes a transaction without the necessary factors like the head of the family and the principal members of the family. Or let's say when the principal members of the family decide to grant an interest in land to another person, the head of the family under the Eje and Apieje principle can bring the action based on these conditions to prevent the transaction from being made. The next subtopic which must be spoken about in relation to management of family property is litigation in respect of family property. As I stated earlier in our previous video, it is the occupant of the stool when it comes to stool property that brings an action in court to enforce any transaction which he deems to affect the family either negatively or positively. And the case of Jenfi and Owusu explain this. However, the case of Kwan versus Nyeni came to change the law in respect of litigation of family property. It is usually the head of the family that brings an action in court to enforce any actions or inactions in relation to their family property, which was stated in the case of Eje and Apieje. However, in Kwan versus Nyeni, the court highlighted certain principles of law which must be established, which grants a member of a family to bring an action in court. The court stated that A, where family property is in danger of being lost to the family and it is shown that the head, either out of personal interest or otherwise, will not make a move to save or preserve it. Or B, where owing to a division in the family, the head and some of the principal members do not take any steps. Or C, where the head and the principal members are deliberately disposing of the family property in their personal interest to the detriment of the family as a whole, or when the member of the family deems it necessary to do these actions. In these special circumstances, the court will give the member of the family chance to be able to represent his family in court, even though there is a head of the family. However, the Kwan versus Nyeni principle has been codified in our laws, and Section 13 of the Land Act touches extensively on what a member of the family under these circumstances can do. So under Section 13 of the Land Act, where a member of the family feels that those conditions under the Kwan versus Nyeni principle have been stated or highlighted, the member of the family can bring the action, but that member of the family must have informed the head of the family to give him chance to be able to take steps which the head of the family deems necessary. If that head of the family fails to do so, then the member of the family, who must have the support of the other members of the family, can institute the action in court in respect of family property. The next part of family property which must be spoken about is the appointment of the head of the family. In the case of Welbeck versus Captain, the court stated that the head of the family is appointed by the principal members of the family. So all principal members of the family must be present when it comes to the appointment of the head of the family. The meeting must be convened specifically and solely for the purpose of appointing the head of the family, and notice must duly be sent to all the principal members. And that was the position in the case of Latte versus Menza. So if a family is seeking to appoint the head of the family, they cannot choose who and who must be there for that meeting. They must ensure to inform all principal members of the family, and all of them must be aware that the meeting they are purporting to go to is solely for the appointment of the head of that family. They must be given due notice in court, in law. So, in the instance that there's a fight in the family which has divided the family into two, one faction cannot on their own accord decide to appoint the head of the family. The whole family must come together, including the principal members of the family, who would then appoint the head of the family. Strangers or persons who are not part of the family can be invited to the meeting, but those people do not have the right in the appointment of the head of the family. Of course, if the head of the family must be appointed, then you should know that he can also be removed. In the case of Abaka and Ambredu, the court stated that for the removal of the head of the family, it must be made by all principal members of the family. It is only right in law that the people who appoint you must also have the right to disappoint you, or in this case, they must have the right to remove you. So in the case of Abaka and Ambredu, it was stated that these principal members must be present for the removal of the head of the family, and the decision must be made by a majority of the principal members of the family. The head of the family must, prior to the meeting, be served with notice to attend the meeting, and he must be given reason of what is going to happen at the meeting. So he must be given the agenda of the meeting. He must be pre-informed that the meeting is to be convened and it is for this particular purpose, which is the removal of him from his position. However, if the head of the family, having been informed of the meeting, decides not to attend and he has been subsequently removed, he cannot go to court arguing that he was not given notice or he was not properly removed. He must be given notice and he must be informed. But if he chooses on his own accord not to attend, then whatever happens at the meeting is at his own peril. The head of the family must also be accountable to his family. Section 13 of the Land Act makes it clear that the chiefs, tendanes, and family heads and clan heads are in a fiduciary relationship with their subjects and members. And I defined fiduciary relationship to be a relationship based on confidence and trust. It's a relationship on utmost good faith, which is evidenced with accountability. So the head of the family must ensure to always be accountable to the members of this family. As a way of recap, I defined what a family is under the customary law in Ghana. I explained how family members acquire property, the rights and obligations of members of the family. I also explained what is to be done in respect to litigation of family property and the exceptions under the Kwan versus Yeni. I also talked about the appointment and removal of the head of the family. I hope this video was able to explain to you everything in relation to family property and you understood what exactly comes with the management of family property. Thank you for joining us on this wonderful session once again. Do not forget to like, subscribe, and comment, and share our videos to your friends. My name is Risa Iris Ewonia, and it was lovely having you here.